thank you for this opportunity to introduce our esteemed colleagues. The gentleman that is Mr. Greg Heavner. He's from Finnegan, Henderson, and Farabow. He's a very famous attorney, in particular trademark infringement, counterfeit, false advertisement, litigation, TTAB litigation. He handles intellectual property issues, including protecting certificate marks for safety quality testing organization. He regularly counsels clients regarding trademark testing organization, searching trademark, copyright licensing, certificate marks. He handles trademark matters in United District Court, cancellation, opposition, proceeding before TTAB, USPTO, and appealing proceedings before CFC. Brett has been attending, executing expert research and seizure of counterfeit goods and copyright infringement involving counterfeit pharmaceutical, counterfeit pipe coupling, and materials illegal copying through computer hacking. Brett is a featured speaker at trademark law seminars, for example, Bench Patent Trademark Office, FDN News, Patent and Trademark Institute of Canada, and UK Intellectual Property Administration Group, and LS Taipei. He's been recognized as the legal 500 US for copyright litigation and for trademark prosecution and non-contentious work.
So, yeah, copyright, as we all know, is going to be covering anything that's basically in fixed media. I think it's basically the same in most countries. It's got to be original, it's got to be fixed media, it's got to be sufficiently tangible to be perceived. Obviously, it's not the idea itself, but the expression of the idea. So this is where the U.S. is, I think, a little bit different from other countries, which is our registration system. Now, in the United States, you do not have to have a registration to have copyright. The registration does not create the copyright protection. The copyright actually exists from the moment that the work is in the fixed media, the moment that the pen touches paper. But there are major advantages to registration. Now, actually, if the work is created in the United States, it actually has to be registered in order for you to get into court. It's like your ticket to get into federal court for your trademark, for your copyright infringement. Now, for works that are created outside the United States, they do not have to be registered, but you get some very, very significant advantages. The first one really relates to damages. Okay, so if you don't have your copyright work registered, you don't get statutory damages. Instead, you as the plaintiff have to actually prove how you were injured and monetarily damaged by the infringement. However, if you have it registered, you can have the judge assign damages based on a scale that's within the copyright statute. There's also an important issue of timing, which is that in order to get these statutory damages, your registration has to take place either before the infringement takes place, or if it's after the infringement takes place, it's got to be within 6 months of the first publication of the work in the United States. So, if you think there's any chance that you're going to be wanting to sue somebody and want to collect damages, you really need to think about having your copyright registered in the United States. Now, the copyright process is not that onerous. You do have examination, but the examination is pretty minimal. They're just looking to make certain that it is, an original work, and that it's not something that's obvious or lacking totally in originality. All right, now moving on from registration with infringement. In the United States, the definition is basically using the work without permission. It can be a part of the work, it can be the whole work. Most of the penalties are civil, but there can be criminal penalties if it's truly a counterfeit situation. All right, so moving on, I think one of the major copyright developments in the United States over the last decade or so has been the Digital Millennium Copyright Act. And one of the reasons that it's most helpful is it's really a direct response to copyright online. So the Digital Millennium Copyright Act facilitates things that are advantageous for both the copyright owner as well as the internet service provider that's hosting the place where the copyrighted work has been put online. So from the perspective of the internet service provider, it creates a safe harbor. Okay? If the copyright owner submits a request for the infringing work to be taken down, and the internet service provider complies, that means they're insulated from liability. They're not going to be sued as either an infringer or contributory infringer. For the copyright owner, this takedown process is so much cheaper, obviously, than suing anybody. So it's really a great advantage for the copyright owner as well. So if you are the internet service provider, the one requirement that you've got to keep in mind in order to take advantage of that safe harbor is you have to appoint someone to receive all the complaints about the copyright infringement, and that person has to be registered with the US Copyright Office. So even if you set up an email address to receive the complaints, but you haven't registered that person with the US Copyright Office, you might not be able to take advantage of the safe harbor. So if you represent an internet service provider where people are posting things on your website, it's very important to let them know about this so that they can go through this step and take advantage of the safe harbor provision. So if you are the copyright owner, how do you go about sending a takedown notice? It's actually really very, very simple. There should be a link on any website where the copyright materials can be posted, and it allows you to either prepare your own complaint, or most of the time they have a form that you can just simply fill out where you identify the URL where the copyrighted material has been posted. You have to make essentially a sworn statement that you're not misrepresenting anything, that you do have a bona fide belief that you own the copyright, and a bona fide belief that it has not been authorized. And so once that is received by the internet service provider, they look at it. They shouldn't really have to take very long to think about it, and they take it down and they notify the person that has posted the copyrighted materials. Then that person that's posted the copyrighted materials has the opportunity, if they want, to respond and say why they think it's not a copyright infringement, or why they believe that they were authorized to be able to use it. And if they do, then it's reposted within about 10 days or so. And if the copyright owner doesn't follow up by filing some sort of a lawsuit or taking other action, it's going to stay up. Okay? But if the posting party never replies, it's going to stay down. So it's a really pretty simple process. That brings us to a case that several years ago. I don't think this is going to probably work, but maybe it might work, but we probably can't hear it. In any case, there was a mother, Mrs. Lenz, who took this really cute video of her baby in the kitchen running around, and in the background, you can hear Prince's song, Let's Go Crazy. And the baby's dancing around, it's very, very cute. And Universal sent a takedown notice to YouTube where this was posted. And YouTube took it down. Now, unfortunately, you can't hear anything because I guess we're not allowed to have audio here at this conference, but you can barely hear Prince's song in the background. It's really hard to hear. It's not like it's a professional, video or anything. It's just mom with her camcorder, the iPhone, recording it and thinking it's cute and putting it on YouTube. So what happens is, it's taken down, and Ms. Lenz is really upset, and she thinks it's fair use because it's not really recognizable. It's very, very minimal, and so she then filed suit against Universal, claiming that they had made a misrepresentation. That misrepresentation being that it wasn't authorized or it wasn't permitted because they should have known it was fair use or it was minimal. And their representation that somehow it was illegal was untrue and therefore violated the Digital Millennium Copyright Act. Now, Universal said, what is it? We don't really have any duty to do that. That's not the type of misrepresentation that was meant. They were arguing that the misrepresentation that was meant was that you didn't really own the copyright, something like that. But the Ninth Circuit disagreed and said you actually do have a duty to consider fair use before you send out a takedown notice. And as a result, under the Digital Millennium Copyright Act, at least in theory, Universal could have been liable to pay Ms. Lenz her attorney's fees and other types of statutory damage. So Universal got a whole lot of bad press for this because it looked like, you know, a crazy bully entertainment company going after the young mom for no good reason. But I learned recently from my colleague Lisa here that there's more to the backstory. I'm going to let you chime in on this.
Well, as luck would have it, I had breakfast at a conference with the Universal lawyer who told me, and I hate to speak ill of the no longer with us, but apparently Prince used to go crazy. And he would stay up all night scouring YouTube. I mean, I would wonder if, the sound on the video is so bad,
It's
I can't
incredible,
believe that
yeah.
a bot would even catch it. But he would go through YouTube videos all night long, and then he would call Universal in the morning and say, sue them, sue them. They didn't really want to sue her, but they didn't have any choice when, you know, you have one of your big stars coming at you and saying,
So I think the lesson that unfortunately Prince didn't learn is that you can actually get into trouble by having a bot do everything mindlessly and just trying to take down everything. So there is a duty to at least consider the fair use arguments. All right, so I'm going to move on from the Digital Millennium Copyright Act and talk about clearance. And we're going to just briefly talk about the clearance because it's very, very important in the United States. And you can get in a lot of trouble if your work that you've created includes works of others that you haven't actually gotten permission or a license or at least thought about for fair use. And that includes, you know, music in the background of the video or anything that you're doing. It can include the celebrities or even a non-celebrity has a right to their own identity. So if those are included, people's names, likenesses, that sort of thing are included, that can be an issue that's going to be clearing. If there's any art or photography that's included in the work that you're creating, you're broadcasting, you're posting, that needs to be cleared as well, the license, and that also includes sports images, events, clips, that sort of thing. So for music clearance, you know, what are the considerations under U.S. law about that? Well, obviously, you're going to want to talk to the music publisher themselves, the ones that own the actual music. But that doesn't end there, because other copyright owners can include the recording company, and it can include the actual musicians themselves. So all of those need to be looked at and considered if you're going to be including music in the work that you're posting or you're distributing. If you're doing a cover or something of your own, where you're doing this, then you still need to talk about the clearance with the music publisher and get releases from any backup performers that you can hire. Photographs and art also are included. And a lot of people forget about that. You know, if you're making like a montage of something and you've got like photographs, or you're trying to make an illustration and you want to use a photograph, people always think, well, maybe, you know, it's some sort of a fair use. It frequently is not the case. There was a case where a publisher of medical journals had photographs in the medical journals, and someone used little bits and pieces of those pages that included the photographs for an advertisement for their products. You could only see these photographs for, you know, split seconds. But nevertheless, the company that was creating the advertisement got sued for that. Now, they eventually ended up winning under the de minimis theory, that you couldn't really see the photographs well enough or long enough. But they still spent a lot of time. It might have been cheaper to just ask permission and check on these things. So you're going to need permission not only from the photographer or the artist, but if there's an actual person in it, which we'll talk about in just a minute, you're going to need their permission as well, the model release. All right, let's talk about celebrities. Now, everything I'm saying about celebrities is basically true for non-celebrities as well. Everybody in the United States has a right to their own name and likeness. This is a matter actually of state law rather than federal law, but many states have essentially the same sort of proceedings. The one difference is if you're a celebrity, in some states, your right of publicity can continue to go on after you pass away. So the estates of like Marilyn Monroe and Martin Luther King Jr. Make significant amounts of money by licensing their images, their speeches, their signatures, and their names. In some states, it can be almost 100 years after they die that the estate can continue to make money off of this. Now, there are other states, I believe New York is one of them, that at least, as far as I know, still says there's no post-mortem right of publicity. Once you're gone, you can't do anything about it. So, one thing to know about, if you're going to be using a celebrity image, you've got to figure out what state's law governs their likeness. In most cases, it's the state that they resided in at the time that they died. States with a big entertainment industry like California, Tennessee for country music have some of the strongest laws relating to how long the right of publicity can exist after their death. And one state, Indiana, I believe, has simply suggested that it can go on forever, as long as the image has value. And I believe at the time that James Dean died, he was officially a citizen of Indiana, so the estate of James Dean might, be able to use his image and name forever. We'll have to see about that. And if you don't pay attention to this sort of clearance for celebrities and even non-celebrities, you can be in big trouble. This is a really interesting case relating to Michael Jordan, the famous basketball player. So Michael Jordan got inducted into the Basketball Hall of Fame, and a chain of drugstores, Jewel Osco, decided to put a big ad in the paper congratulating him and saying, how great it was that he was now in the Basketball Hall of Fame. And they didn't use his photograph. Instead, they used a photograph of shoes, which are the same brand that he uses, with his number on it, number 23, and then his name. Now, you would think maybe this wouldn't be such a big deal. They're just being kind of nice and saying, how great it is that he's been inducted into the Hall of Fame. The unfortunate thing is it was viewed really as an advertisement. And what's not clear from the picture here is underneath it they actually had coupons that you could clip out. So the idea that they were trying to argue it wasn't really a commercial usage, it was just a goodwill gesture, kind of fell flat. And they ended up settling the case. And I don't know the exact sum, but it was a very sizable sum. So this is a good example of how it doesn't have to be their face, it can be a subtle type of thing, and still be considered commercial use that's not offered. Now, this is an interesting case because the issue here is whether or not you could recognize that baseball player. This is Don Newcomb, and here's the photograph, and this is a piece of art that an artist kind of put together that was selling in baseball memorabilia stores. So the idea is, if you could buy this art and show how much you love baseball, and you decorate your sports room or whatever. And he did not get Don Newcomb's permission to do this. And he argued, it really doesn't matter because you can't see his face, right? How would you do that? And even the number, is hard to see. It might even look like a 36 rather than 39. So, how is it that Don Newcomb can sue me for violating his right of publicity? And Don Newcomb argued, and he was successful, is that his pitching stance is so unique, the way he holds his leg and holds his arm, that everybody that was a baseball fan would know that was Don Newcomb. And so therefore, the artist and the company that represented them and distributed the poster, the artwork, was liable for violating his right of publicity. And it can even be something that is not visual at all. This is a famous case where the singer Bette Midler, she's got a very distinctive voice, a very distinctive type of sound. She had told Ford Motor Company, wanted to use one of her songs in an advertisement. And she had told Ford, no, you can't use my voice. Now Ford had actually gotten, I believe, the publisher of the song permission to use the song itself, but they couldn't use the recording by Bette Midler because she wouldn't give permission for her voice. So they hired a singer. And they told the singer to try to sound as much like Bette Midler as possible. And they did, and they ran the commercial. And needless to say, the divine Miss M was not happy about that, and was actually successful in suing based on the copying of her distinctive voice. So even though they did fine with the actual song itself, and they didn't use her face, and they didn't use her name, they were actually held liable because it sounded so much like Bette Midler that she was convinced to think that she had sold out and made this for the commercial.
So this poor singer cannot sing anymore.
Well, she can sing something like herself as long as she does. I mean, it was. I don't think it was like a natural thing where she like just couldn't help herself that sound like Bette Midler. She intentionally altered the tone of her voice, the way she phrased things, the way she sang the song to make it sound just like Bette Midler did in the original recording.
So is that a kind of infringe her personal interest instead of infringe copyright issue?
That's right. That's right. This is really more of a right of publicity type of thing. And so even though the copyright in the song itself, the words, the music, that was not the problem. The problem was the sound. It sounded like Bette Midler. And this is, as I said, a matter more of state law rather than federal law because each state is slightly different. But they're all basically the same type of test. So it shows you it doesn't have to actually be literally the face or literally the name. It can be any sort of identifying feature like the sound of the voice. Now, this is an interesting case. I don't know if people have been to New York Times Square recently, but there's always been this guy out here, the naked cowboy. The naked cowboy stands in the middle of Times Square, and he strums his guitar, and he sings little songs. And Times Square also features the M&M store. It's a new store, and they've got a huge billboard, electric billboard, and they, in a way of trying to make fun and trying to poke things about being a New Yorker, they dressed up one of their M&M characters like the naked cowboy. Well, the actor that plays the naked singing cowboy sued M&M for infringement of his right of publicity. And he failed. And the reason he failed is because it wasn't actually him, it was a character. And so the right of publicity doesn't extend to a character. And his character wasn't really in a fixed medium, so it's not really a copyright. There was no particular photograph or anything that was being copied. It was just the idea of somebody standing around in their underwear with a cowboy hat on, singing a song. And so this kind of, I think, shows you the outer limits of what you can do with right of publicity. You can't have a right of publicity in a character. It has to be the actual person. All right. So most of the things I've been talking about earlier with these rights of publicity and these character, so these celebrity names, images, really have to do with kind of commercial usage. But what about artistic usage? What about if you're creating, a film or some great, artistic work that references a celebrity? That is a different test. And the test there really relates to balancing the artist's First Amendment rights to create this, wonderful artistic work and the right of a celebrity to their own image and likeness. And this case came up with the Rogers versus Grimaldi case. In that case, there was an Italian film about two aging dancers that used to have an act where they would pretend like they were Fred and Ginger. And they would dance just like Fred and Ginger and use their dance moves. And Ginger Rogers was not happy about it because she hadn't given permission for them to use her name and likeness. And so she sued. And the test that's come out in these artistic settings is, does the use of the celebrity's name or likeness have a relevance to the work? And so if it does, if it's part of the actual critical storyline, part of what makes the artistic work art, then it's probably going to favor the artist and allow that to continue under the First Amendment. Versus a situation where it might mislead the public. And if they decided that the public didn't really think that Ginger Rogers was in the movie. It didn't actually show Ginger Rogers herself. And so as a result of this balancing test, using her name in Fred and Ginger in the movie and having some older actress kind of mirror some of her dance moves was not considered to violate her right of publicity because the First Amendment was So everything I've been talking about earlier here is really about clearing the rights, clearing the copyright, clearing the right of publicity, clearing other things you're going to use. And what if you don't want to do that? What if you want to just say it's fair use? Well, fair use is something you can do, but it can be kind of complicated. The key thing there is making certain that you are really creating something new. It's really more for the artist. and you're transforming the work. And you're not taking the entire previous work that was out there. So while it can be cheaper, it only works in certain circumstances. So that's all I have to say, and I'm going to turn it over.